Welcome back. Now let's assume in our hypothetical involving non-compete agreements that you represent the defendant employee against whom a breach of contract claim has been filed, alleging that the employee competed against the former employer in violation of the terms of the non-compete agreement. After completing the objective analysis in the memo outlined earlier, you are asked to draft a memorandum asking the court to dismiss the employer's claim. In a persuasive memo, you will still present the facts, rules, and application, but present them in a way that compels the court to rule in your client's favor. So how do you transform your objective analysis into a persuasive brief to the court? First, let's review the format of the objective memo and see how a persuasive memo would differ. The objective memo had a question presented, brief answer, statement of facts, discussion, and conclusion. Typically, a persuasive memo will have a statement of facts, argument, and conclusion. In a persuasive memo, typically the question presented and brief answer are included in the argument section rather than appearing separately. The statement of facts in a persuasive memo should contain persuasive facts, not neutral facts as in an objective memo. You should convey the facts in a persuasive manner by telling the story, if you will, from the client's perspective. You may also use some other persuasive techniques here, such as emphasizing positive facts by placing them in prominent locations, such as at the beginning and end of sentences, and providing lots of detail, while de-emphasizing the bad facts by placing them in the middle of paragraphs and providing only broad statements about them. A good test to see if the facts are presented from the client's perspective is if the first few sentences make it clear whose facts they are. Under our example, the facts for the employer might emphasize the company's history, the kinds of business interests it has, the employee's acceptance of the non-compete agreement, and the resources it expends on soliciting prospective clients. By contrast, the employee's statement of facts might include the employee's personal history and the specific ways in which the terms of the non-compete agreement impose a financial hardship. All facts material to the legal analysis must be included in this section. The argument section has the same creek organization as the discussion section of an objective memo, except that the analysis is geared to persuade the court to adopt your interpretation of the law and how it applies to the facts at bar. Now that we've covered the basic ideas behind advocacy and the basic mode of written legal communication, the legal memorandum, let's take a look at three aspects of constructing a persuasive written argument. I'll call the three S's: substance, structure, and style. First, the substance of your argument. This is the most important aspect of a persuasive argument because it is the legal argument itself. When preparing to make a legal argument regarding a case, the first step is to get a firm grasp of both the facts of your client's case and the underlying law that is applicable. At this stage, the best approach is to be objective in your reading and analysis and identify all arguments available on both sides. Next, evaluate the arguments and decide which ones are most likely to succeed based on the legal support. What kind of authority is applicable, and what type of reasoning can you employ? Think about the different kinds of authority that might be applicable here. First, is there black letter law, a code, statute, treaty, convention, or regulation that applies directly to the facts at hand? Is the meaning clear from the language of the law, or do you have to look at legislative history to glean the intent and purpose behind the law? If there is black letter law, consider how you can frame the law or rule persuasively and imbue it with your client's point of view. This is a very important aspect of persuasive writing that I will elaborate more on later. Second, are there cases that have interpreted the law that can be used analogically? If so, are you able to develop a synthesized rule from the cases and frame it persuasively? Here, let me say a word about legal analysis based on common law or judge-made law. Some jurisdictions rely very heavily on case law as a source of legal authority. Case opinions sometimes contain explicit reasoning underlying the decisions. On the other hand, many cases do not, and one must rely on understanding the implicit reasoning to make sense of the court's decision. In these jurisdictions, rule synthesis is necessary to make sense of a large body of cases that do not necessarily articulate a clear overarching rule. A third source of legal authority may be broader policy considerations. Perhaps the law or case is not explicitly supportive of your argument, but implies a policy consideration that is supportive. Policy arguments can be powerful and effective. So a good advocate considers each of these types of reasoning, rule-based, analogical, and policy-based, in crafting a persuasive argument that will convince the court. The second aspect of written advocacy to consider, the second S of the three S's, is the structure of your argument. This is a critical component of successfully persuading the court to find in favor of your client. Here, a thoughtfully created outline of the overall argument, one that prioritizes the main points and organizes the authority supporting each point, is extremely helpful. How you should organize the arguments depends on the specific nature of the legal issue or issues. As a general rule, it is best to begin with the strongest arguments. Beyond that, see if there is an inherent logic to the legal analysis. For example, is there a threshold issue that must be addressed first? Are there broader, more fundamental concepts that need to be explained first before addressing more specific issues? Are there multiple elements of a legal test that need to be addressed one by one? The large-scale organization of the argument section of a persuasive memo may follow the Creek paradigm for each legal issue, just like the discussion section of an objective memorandum. Remember Creek: conclusion, rule, explanation, application, and conclusion. Remember that paradigms are especially useful for new legal writers as they learn how to structure arguments, but will eventually become second nature. Let's take the first C of Creek. State a thesis or proposition, a conclusion you want the court to reach. Then state the rule or general principles governing the legal issue. Next, the E, explain the rules through case descriptions and comparisons. Next, A, application, apply the rules to the client's facts. And finally, C, conclude. So I've discussed substance and structure. The third aspect of advocacy to consider is style. The style of your argument, or the manner of expression, also contributes significantly to the overall persuasiveness of your argument. There are a couple of aspects of style that are worth highlighting. First is tone. An argument should be delivered with the same authoritative tone that an objective discussion of law would have. Persuasiveness does not come from the use of strident language or emphatic adjectives such as definitely, clearly, obviously, absolutely, etc. Rather, stating the argument in a direct, matter-of-fact, and authoritative manner is often the most effective way to persuade. In other words, be persuasive while sounding objective. The second key style consideration is word choice. Legal writing should be clear, precise, and concise. Choose plain words to mean exactly what you want them to mean and be consistent in their use. Complexity or lack of clarity in legal writing is often caused by poor word choice. Ambiguous or unnecessarily obscure language, sometimes called legalese, should be omitted in favor of shorter, more direct words. Redundant or superfluous language should also be eliminated. Only words that serve a specific purpose should appear in the document. Use transitions effectively. Include transitional words to serve as road signs for the reader and to facilitate the overall clarity and comprehension of the argument. Paying attention to the three S's, substance, structure, and style, should help to make your legal argument powerful and persuasive.